Yes, thank you.
Thank you, Lord. I was going to start with the code. That is to be found at 1813 of the bundle. And the first paragraph I need to look at is paragraph 3 on 1814. This is the menu of code rights that we've seen before, including a variety of different things. Just a couple of points to note about it at this stage. The first is that some of these rights are more intrusive than others. For example, the right to put apparatus and to keep apparatus on the site may be intrusive. It need not necessarily be intrusive. So, for example, an example came up earlier as to a rooftop aerial, which may not change matters of occupation. Another is, as we'll see, the definition of lines includes things like underground cables and ducts and so forth, or in an urban setting, cables through a dry riser through the common parts up to a roof, that kind of thing. Those aren't going to disturb occupation, but clearly some other more intrusive types of apparatus would be likely to disturb the occupational status of the property. A point's made against me that there's something to be gleaned from paragraph 3 about the fact that one of the rights is to keep apparatus installed. We say there's no significance to that, in that what's been looked at in paragraph 3 is the right to do anything. Now, the right is usually granted up front. So the right to install and keep installed is something that is granted when the occupier is in a position to grant that right. It's not necessarily, and it's not even naturally, looking at a right to install first, followed sometime later by a right to keep installed when you've put the mast up or put the apparatus on the property. It's no real different in this code from the standard kind of provision that you see in a lease, which is the right at the outset to erect and maintain a building on site, or the obligation, to take a slightly different type of clause, to insure and keep insured, or to repair and keep it repair. This is the same kind of thing. At the outset, you can be granted the right to install and to keep installed certain apparatus. So it's not assuming that at the time of the grant, the installation will already have been there.
But it's providing for that possibility. You might have a situation where you don't yet have a right, but the apparatus is already there, and therefore you're obviously not going to ask for a right to install it, but to keep it installed.
Yes, there's a theoretical possibility that there is something already there. But if you're new to the site, you're the one who wants to get rights on the site, all that means is that you don't need the first right. Mm. You just move straight to the second one. Mm. The point that's taken against me is that you might be the person putting up the apparatus. You then have occupation of the site because of that fact. And then you can't seek a right to keep it installed. Now, that's not what paragraph 3 is all about. It's an entirely theoretical possibility. Paragraph 3 is just about describing the rights. Those rights would tend to be granted up front. And if you're going to take a right to install, you would expect to take a right to keep it installed at the same time. Moving on, paragraph 4 is about the...
Well, with E, for example.
B, yes.
E.
E, yes.
Carry out any works. I mean, what is when the right is applied for, do you have to specify the works, or do you get the right to carry out any works, however excavatory they are for the whole, at any point during the whole fixed term, or do you have to specify when you ask for the right what kind of works you're talking about?
It will usually be the case that these basic rights are then worked out with extra terms as to when and how and for what purpose they can be exercised. So something like this one, this is E, to carry out works, is likely to be accompanied by some definitional material in the agreement. But the real answer to your ladyship's question is that it's all a matter of agreement between the parties. This menu at paragraph 3 just sets out the nature of the right. What you actually get the right to do will be whatever you agree. And that will depend upon the particular circumstances of any side. So my next...
But you say frozen in time.
Well, the position is as it is agreed at the beginning. So if you've conferred rights to install whatever and to keep that installed, that will be your agreement for the duration of the agreement.
Yeah, it's contrary to everything we understand about contract law, isn't it? Parties are always entitled to amend their agreement if they agree. But you're saying, no, they can't do that. Prima facie, all that they can do is, at the end of the agreement, go to paragraph part 5.
Well, there may be some room for consensual agreement. The real issue is the extent to which that amends the agreement as a code agreement. If there are implications for its status as a code agreement, as opposed to merely being a consensual arrangement between the parties. That's the issue that's really at stake here. Paragraph 11, remember, does contemplate the idea of a variation. So I'll address that, if I may, in due course when we get there. Looking at paragraph 4, we have the statutory purposes, and they are the purposes of providing the operator's network or the purposes of providing an infrastructure system. And so these are public purposes. And as we know, this is not, therefore, a private right code. It's intended to form a scheme for the establishment of public rights of this kind, albeit through the mechanism of agreements between parties. And then paragraph 5 is the definition of electronic communications, and that includes fairly wide definition at 1A of apparatus designed or adapted for use in connection with the provision of an electronic communications network, and apparatus designed or adapted for a use which consists of or includes the sending or receiving of communications or other signals, and so on. Then it includes lines and other structures or things designed or adapted for use in connection with the provision of an electronic communications network. Lines is defined at 3, and that includes the kind of cabling I was referring to earlier, wires, cables, tubes, pipes or similar thing, designed or adapted for use in connection with the provision of electronic communications. And the structure includes a building, only if the sole purpose of that building is to enclose other electronic communications apparatus. So, pretty wide definition, but I would suggest, contrary to my friend Mr. McGee's submission, that it doesn't include offence. The way he sought to argue it is that it comes under 5.1d, which is a structure or thing designed or adapted for use in connection with the provision of an electronic communications network. Well, it may be a structure or a thing, but it's not designed or adapted for use. A fence is a fence. There's nothing designed or adapted about it for use in connection with the provision of a network. We suggest something like a fence would fall outside definition of apparatus. For what it's worth, I'm not suggesting anything in this case turns on small definitional questions of that kind. We then proceed into an important section, which is part 2 of the code, which is headed Conferral of Code Rights and Their Exercise. And paragraph 8 explains what this part is all about, and it divides the conferral of code rights from the persons who are bound by code rights, and then the section also deals, or the part also deals with the exercise of code rights. And the first of those is dealt with by paragraph 9. Who may confer code rights? A code right in respect of land may only be conferred on an operator by an agreement between the occupier of the land and the operator. So in other words, the public purposes that are intended to be achieved by this code have to be conferred, or have to be achieved by the conferral of code rights on operators, and that can only be done by agreements between occupiers and operators. Now, it's one of the points that said, I think, against me, is that contemplates that an operator will be different from an occupier. Well, of course it does. That's exactly what it says. You're not having an operator conferring anything on himself. On the contrary, he has to go to an occupier if he wants to seek code rights.
Well, then it goes a bit further than that, though, isn't it? Because the intention obviously is that there's someone who he can go to.
Yes. Yeah. No, well,
and not himself.
Absolutely. Absolutely. Now that raises a really important point about the way in which Section 9 or Paragraph 9 operates, and the policy decision that's been taken to set the bar in this way. Let me just, if I may, take a run at dealing with that observation of your lordships, if I may. The question of who is the occupier is the subject of a definition, and we've seen that. That's paragraph 105 on page 1874. And essentially, it's a question of fact as to who is the occupier for the time being. I think 105, I haven't looked it up, is the occupier for the time being. So what it's saying is that is a factual question about who is, in fact, in occupation. There is what my friend calls the cascade in 105.6 that comes into play, but only if the land is unoccupied. So that is the way in which you come to the cascade. And on the cascade, the first item of those is whether anybody is in fact exercising control, management and control of the premises. So that's another factual question. So that's the way in which the definition operates alongside paragraph 9. We're looking at the question of fact of who is, in fact, the occupier. Now, there is no part of that definition which says that if any person is, in fact, in occupation, you will leave him out of account. His occupation is to be disregarded. On the contrary, if he's in occupation, you have to take him into consideration.
Well, that's obviously a mistake that the drafter has made, and the question really is whether we can rectify it. You can't have intended to create a situation in which there's no one who can grant rights to the operator because he's the occupier as well.
The point your lordship put to me was if an occupier can't be found, which was the point I was just about to deal with.
All right, well, I expressed it loosely. if there isn't, if the occupier, if there's nobody whom he can contract, who can grant him rights because he is treated as the occupier under the definition, that would be a nonsense.
Well,
it may be a nonsense that we can't do anything about, but it is a nonsense, isn't it?
My answer to that would be it's not a nonsense. So let's just take what's going on as a matter of policy.
Well, I think your position, the argument you were about to develop, was that there was a policy reason for the restriction in
Yes.
paragraph 9.
Yes.
I think we better hear you on that.
Well, let me go there. The first is the explanation crisply made by the Chancellor in the Bridgewater Canal case. That is, for your Lordship's reference is page 2303, paragraph 26. I won't look it up. That's an old code case. But the policy reason behind it was identified by the Chancellor as being he's the person, the occupier is the person primarily affected and most easily identified. And then we've seen, and these are references in our statement of case, so I won't turn them up now, but we've seen in the Law Commission's consultation paper at tab 11, which is page 2174 and 2177, paragraphs 329 to 30 and 340, that essentially what Sir Andrew Morritt said as the policy reasons are indeed the policy reasons behind the making the occupier the sole person who can grant rights. In other words, there are two advantages of making such a person the only person you need to deal with. One is you have a single point of contact. You only need to find the occupier. The second is that he's readily identifiable. Now, I accept your Lordship's point that in some situations, some factual situations, it may in fact be difficult to work out, in a particular bit of open land, for example, who is the occupier. But that is just a practical consequence of the policy decision that's been taken by Parliament to set the bar in this way.
But they aren't advantages if it's you you identify as the occupier.
I'm not sure I follow that, my Lord. Could you...
Well, if you're the operator and you want to know who the person primarily affected will be, if you ask for a code right, and who's most easily identified, it's not much help if you consult the definition and it says it's yourself.
Well,
it's self-defeating.
Yes, but these are all practical problems rather than legal ones. The legal position is perfectly clear. You have to deal with the occupier. So if there is an occupier, there's no problem in applying the definition. Mm-hmm. So the problem that your Lordship's raised only arises as a matter of practice if you're unclear, for example, as I say, in a large, wide area of land, who is the true occupier.
Well, the problem I identify arises if it is clear that the operator, are the occupier under the definition,
yes,
as it looks on its face, because you are the person who, in practice, has control over the area around the apparatus.
But when it comes to the conferment of rights by agreement, it stands to reason that you will not be seeking to confer rights on yourself. I think we can all agree with that. I think that's the point that is suggested against me, but I adopt it because it's part of my argument. But it leads to practical problems, and it's important to just sketch those out. The advantage, as I say, is that you have a single point of contact who is readily identifiable. The disadvantage, and it is a serious disadvantage, is that when you go there, there is something about that occupier which makes it difficult for him to grant you the rights that you need. Now, let's just think about that for a while. suppose the actual occupier has rights in relation to the site which are, to a greater or lesser extent, precarious. So, for example, he is in occupation, he is in fact in occupation, but as regards himself and the landowner, he's a trespasser. Now, that kind of situation can arise where you have long-term people acquiring possessory title. That is a person in occupation, and there is some long-term history to it, but he is a trespasser. So you go to that person and you wonder how you're supposed to get any rights worthy of the name from him. You can multiply the examples across the board. So another precarious type of occupier would be a licensee. Another one would be a tenant at will who's holding over after the end of a tenancy. Another one would be a periodic tenant whose rights can be brought to an end by a fairly short-term notice to quit, with or without any statutory protection available to him. Now, in each of those cases, that is the occupier, and that is the only person you can deal with as an operator to acquire code rights. But the practical consequence of that is that it must be, in some circumstances, completely unwise and inappropriate to try and obtain code rights from that person.
But that's not an insuperable problem, because you can then go off and get the court to impose an agreement, and you can get other people bound. Once you've got your foot in the door of paragraph 9, you can get agreements imposed on all the relevant people. The problem with your interpretation is that if the operator is the occupier, he can never get his foot in the door, so he can't bind anybody else.
Well, let me take that in stages. Point one is, no, that doesn't work. If you've got an occupier with limited rights, you can't bind somebody else to the position after the occupier has gone, because that would be that person conferring rights after an occupier has gone, whether or not he's in fact in occupation. So the usual position is you go to an occupier and you say, I want some rights from you. You get your rights conferred from that occupier. The person who is bound isn't a successor or doesn't become bound by those rights after the first rights have fallen in. It's not that kind of binding. It's what it requires to be bound are the rights that can be conferred by that occupier. So the best he can do is to say, I will give you the rights to put your code rights, to exercise your code rights on this property for so long as I've got the right to allow you to do that. But the successor or the reversioner or the landlord who has title is outside that process, because on this hypothesis, that landlord is not the person in occupation and cannot confer rights now or in the future. Now, if he changes his status because the original occupier goes and the landlord becomes the occupier, at that stage the landlord can be asked to confer rights. But at the early stage, it's only the occupier who can confer the rights. And the person who's bound is somebody whom you may need to bind into the process for some property or other reason. Let's just think who that might be.
So wait a minute. So you're saying that suppose the person in occupation is a tenant with a two-year lease. You say you have to go and get the right code rights from that tenant. You can't improve the position by going and also getting code rights that bind the landlord, because the landlord can only be bound for 2 years, because he can only be bound by the same right as is conferred by the tenant.
Yes.
So then what happens after 2 years? Or do you just have to say, well, that site's hopeless then because we don't want to spend £100,000 installing a mast and we might be...
That's where I'm going with this. My submission is that because a limited occupier, an occupier with limited rights, can't give you any valuable long-term rights, you actually, as an operator, you have to walk away from that situation. You say, you can say, this site is perfect. Geographically, technically, it's in every way, it's a perfect site for me. But I've made inquiries of the occupier. It turns out he's a trespasser. He could be thrown off at any time. I don't fancy the idea of taking rights from him. And the consequence is you have to look somewhere else. Now, that's what I mean about...
Look somewhere else for a different site.
For a different site, exactly. So the way in which this works, and this is the consequence of choosing an occupier as your point of contact, is that you do have the advantages that Sir Andrew Morritt pointed out, which is it's easy and you know what you're dealing with. You can identify the person. But you, on the other hand, the disadvantage is you're stuck with whatever rights he's got. And if he has precarious rights, then you might have to walk away from that site because you can't get the rights that you need to justify the capital investment in that site. What is, to put it another way, what this paragraph shows is that there is no general entitlement to muscle in to your preferred site and insist, whoever owns it, whatever the occupier is, insist on your code rights being granted. That's not how the code works. The code works by occupiers granting code rights which are acceptable to the operator.
So what length of rights does AP Wireless have over all the sites that it operates?
It tends to take long reversionary leases to, for either from a freeholder, sorry, rewind. If the operator is there under a lease, then APW will take a reversionary lease and therefore, for whatever period, I mean, that's all a matter for discussion between him and the landlord, but it takes over the position of landlord, essentially. And there are other situations where it will acquire land for itself and then make a site available for operators. So that's its business model. Hmm. So, but what paragraph 9 is saying is, from the operator's point of view, is you have to go to an occupier. Now, that means that there is an inherent limitation on the availability of sites that will be suitable for the creation of an infrastructure network. But of course, that unsuitability derives from the policy decision that it is to be the occupier, which is the sole person from whom you can acquire code rights. Now, that's worth considering, because it doesn't mean, and perhaps the impression has been given by my friend's submissions, I'm sure he didn't do it deliberately, but it may be that the impression has been given that whenever you want a site as an operator, one way or the other, you'll get it, because you'll do a deal with the occupier and you can extend it somehow and get it binding after the occupier has left. That's not how it works. You have to do a deal with the occupier. You're stuck with whatever rights the occupier has. That may not be enough for you, in which case you have to walk away from the site.
But But if that's one on which you've got some existing equipment, that's a pretty unfortunate situation.
Well, yes.
You're now stymied because you've become the occupier and you've got to walk away and find somewhere else.
Yes. Can I address that this way? I'm looking at this code, and I'm inviting the court to look at this code, as it were, clean. So we don't have the history of apparatus having got onto the site under some old code. You look at this provision. This provision says, if you want rights, you've got to go and deal with an occupier. That is, if you want these code rights, you have to deal with an occupier. And if you happen to be the occupier for some historical reason, that site will not be available to you any more than it would be available to you if all you can get is the fag end of a holding over right from the current occupier. It's just not practical.
It'll create the situation going forward, though, won't it? When people put equipment on and become the occupier as well as the operator, then that site's dead for any future conferral of code rights.
Well, what tends to happen, of course, is that the operator identifies somebody, as it were, with whom he can do business, who has a reasonably long interest in the property, whether that's freehold or long leasehold, and reaches a deal with that person. And then he's got the comfort that he knows there's no difficulty about the occupier going out of possession, because his lease is going to continue. And he may have all the Part 5 renewal rights as well. And as I will come to it, occupation under Part 5 is not a relevant consideration. So at the beginning, he has his rights conferred under a new code agreement. He exercises those rights. At the end of that, he gets a renewal. There's no title problem, as it were, with the occupier. So because he checked that there was no title problem. I mean, it doesn't prevent title problems from arising during the course of the agreement. For example, because the occupier's lease is forfeited, for example, and there's therefore a change, or he goes bankrupt and that forfeits his lease. Something of that kind. There could be changes, of course, but the operator takes the occupier as he finds him and only has the rights that the occupier can give him. So the practical consequence, my lady, in answer to your point, is that the operators will, in fact, hunt around for somebody who's got decent rights, that gives them sufficient security for the length of time for which they need that particular site.
And that's going to be AP Wireless, effectively.
It could be. Certainly we are in the market to offer that service.
Right. Excellent.
I mean, actually, looking at the parties in the court, let's not forget that the operators are not mobile network operators. The operators before the court here are two infrastructure providers. So what they do is a slightly different version of what we do, which is they find sites and they set them out for mobile operators to use. And then they do deals with operators.
But it's a joint venture between two operators.
Not anymore, it isn't. It might have been once. Cornerstone used to be owned by Vodafone and another, I forget who now. EWCA. But no longer. It's now, they're both independent. Both these two, On Tower and Cornerstone, are both independent operators now. So they will perhaps put up some kind of mast with electronic apparatus, and they will then share that with operators under whatever terms they agree with operators or operators are prepared to pay. And that's their business model. And we do something similar, but without being an operator, a WIP, as they call it, a wholesale infrastructure provider. But it's the same kind of thing. So, going back to paragraph 9, it needs to be borne in mind that, as I say, that you don't get the right as an operator to go on whatever site you want and do whatever you want at all times. You are stuck with the limitations of the occupier that you are forced to deal with. And the point, if I haven't made it clear, is that that consequence is a deliberate policy choice. There are other ways it could have been set up. You could have had the ability to insist upon a freeholder granting rights which would then override subordinate leases and occupiers. You could have had some other alternative means of somebody conferring the rights. But the choice taken, the policy choice taken, was to leave it to agreement between the occupier and the operator. And there's nothing surprising about that, because we know there are clear historical precedents going back to the Telegraph Act 1863, which is in the bundle, and we know that the old code also, from 1984, that is also limited to acquiring rights from an occupier. So it's got a long history, this policy. It's not a mistake. And it may be said that it's slightly arbitrary in its effect. And indeed it is, because you're stuck with the arbitrary factor of whatever occupier you have to deal with.
Can I just check that I'm understanding this? Suppose you've got one of your precarious occupiers. No one knows how long they're going to be there. You seem to be saying that they could not grant a code or enter into a code agreement that, let's say, gave an operator 10 years of code rights, that somehow the precariousness of their occupation of the land will affect the code rights that they purport to grant.
Yes. They can only grant what they can grant.
Well, they can make any promise they like. So in my example, they might be there for 10 years, they might not be there for 10 years.
Yes.
They promise the operator, you can have the rights for 10 years.
But
I just so you understand my puzzlement, reading the code, I'd rather got the impression that in that sort of situation, the code rights which are set out in that agreement then assume a sort of independent existence, and you can, the operator can then go to the court to force other people to recognise those rights for the whole 10 years, in my example, even though the occupier who granted those rights might be kicked out after a year.
Well, it doesn't work like that. And my suspicion is it can't work like that.
That's what I want to say.
Because of the provision about the conferral of rights. The rights can only be conferred by an operator, as an occupier, for so long as he is in occupation.
But then what happens then if you're the operator, you enter into an agreement for 10 years with the occupier, who is, let's say, the only person with an interest in the land, but then you become the occupier of the site by fencing it off and so on. On your analysis, then the code right ceases to be effective.
Yes, but on my analysis...
You've destroyed the code right that you've acquired.
Well, yes, but on my analysis, you wouldn't go into that situation in the first place. That's the point.
But it's every situation.
No, it's every situation where the operator becomes an occupier by installing the equipment on the land and then fencing off around it, let's say.
Let's think about what happens after... My Lord Sale's example was of somebody with a 2-year... let's not call it an interest, but a 2-year precarious right of some description, and enters into a 10-year deal for the code rights to be effective. How can you get that binding on a landlord after the 2-year period? The landlord says, I'm only bound by this occupier's rights for so long as he's there. He's only there for the next 2 years. So you can't bind me.
Well, don't you then, if you're the operator and you have an occupier with a limited or precarious right, you don't know when it is going to end, can you not approach the landlord under 10.4 and get him to be bound? He'll say, okay, the occupier may go, but I'll honour this agreement.
Yes, that seems to be a possibility, but it runs into the problem that after the occupier has left, there is nobody who was in a position to confer rights. So it may be that...
Or whoever is then occupying could confer rights, but once the right is conferred, do you need it further conferred?
Well, certainly my submission is, and my understanding of the practice is, that you don't seek rights binding on third parties who are not bound to accept such rights because of their relationship with the occupier. So you are looking for long-term positions, as it were.
But I thought your answer to Lord Hodge seemed to be opposite to what you had answered to me. I thought you were saying if you've got a tenant with a 2-year right, or even a 10-year right, which is always precarious because they might forfeit the lease for some, that you can't improve your position by getting the landlord bound, because the only right that the landlord is bound to respect is the same length and stability of the right that you've got from the occupier, though why you would need anybody else to be bound by that right I'm not quite sure. But I thought you were saying that the operator couldn't get any further comfort by getting people up the chain bound by the right, because like a dominoes, they all fall once the occupier falls. But then I wasn't quite sure. I mean, as I understood Lord Sales's point, it was not a 2-year precarious lease. It was that the lessee has a 10-year lease or a 15-year lease, but it can be forfeited or it can be terminated on notice. So what is then the length of that code right? And if the landlord terminates that and you say, well, I've got you bound under 10.4, he says, no, I was only bound to the extent that the occupier was bound. His lease has come to an end because I've brought it to an end, so my boundness has also come to an end.
Well, that is a permissible stance for the landlord to take, which is, I'm only going to be bound for so long as the occupier is bound. So he doesn't become bound to some length of time in which the occupier is not there, has ceased to have any ability to allow the operator to operate from the premises.
But you say that's a permissible stance for him to take. I understood you earlier to be saying it's the only stance it's possible for him to take.
Yes, indeed.
Well, I'm struggling to understand why that is the case.
Yes.
Because if you start off with 9, what is conferred is a code right in respect of land by the occupier. The prudent operator also goes to the landlord, realizing that the occupier's position, although maybe on paper it appears to be a 10-year lease, but it's terminable on 6 months' notice, is to that extent precarious, and says, will you be bound by these code rights which the occupier has conferred on me? If the landlord says yes in return for a modicum, then why isn't that an arrangement, a conferral of a code right in terms of the scheme?
Well, let's just take it in stages. First, let's think about the payment of money under an agreement of that kind. The operator is only going to want to pay the occupier for so long as the occupier is able to give him the rights. So on the example we're thinking of, the rights of the occupier in respect of the premises come to an end after a couple of years. Who then is going to be the person in receipt of the rent for the remaining period of the rights purportedly granted? Because the landlord, let's assume it's a landlord, the landlord doesn't automatically take a reversion to a code agreement. That's a property concept. We're not into property concepts, we're into code rights. Code rights get exercised according to their consideration as between the parties to it. The only party is the outgoing occupier.
But no, I mean, 10.4, the landlord has agreed to be bound by it.
Well, but has agreed to be bound by it. What does that actually mean? He's agreed to be bound by an agreement between the occupier and the operator. He's not bound in the sense that he takes a reversion of the operator's rights when the occupier's rights when the occupier's rights fall in. That's not just being bound by somebody else's agreement. That's having an agreement of your own, which enables you to take advantage of some consideration. Now that is not the kind of agreement which is contemplated by the obligation under paragraph 9 to deal only with the occupier.
Isn't he agreeing to be bound by the code right, not by the agreement? I mean, that's what it specifies in the next subparagraph 5.
But the code agreement is an agreement to confer code rights upon the terms of the whole agreement. So I'm not sure one can split off aspects of the agreement.
But what's then ever the point of getting somebody else bound to
the obvious examples are where you need a third-party consent of some description to avoid unlawful sharing of occupation. So, for example, the classic example is a superior landlord has the benefit of a covenant with a tenant whereby the tenant will not share occupation without the consent of the landlord. So it becomes a breach of covenant if you don't get the consent of the landlord. And so in those circumstances, you would either negotiate with the landlord, but if you can't reach an agreement, you might apply for him to be bound by whatever right, and compensation would be paid as fixed by the court. So that's the sort of classic thing. There aren't many situations where you need to have the third party bound, but people with reversionary rights or the ability to cause forfeitures, they're very much the people you want to have bound into the existing rights. But what they don't have is the obligation to continue to observe any rights granted between the occupier and the operator after the occupier's rights of occupation have come to an end.
Well, that would be fine if the operator could then apply for the code right to continue as against a new tenant or the landlord. But on your case, he can't because he's now the occupier.
That's right, and he can't. But the logic of that is not that there's difficulty in the code, but it means that for practical purposes, you make sure you get your ducks properly in a row before you commit capital investment to a precarious position. In fact, you avoid precarious positions altogether.
But that may result in you being limited to sites which are very suboptimal in terms of their suitability for what you want to use them for.
Well, in theory, I suppose that's right, but there's no limit on the sites that are available. I mean, this is countrywide. There's all kinds of sites available, and there must be better options. And in practice, we all have the benefit of a mobile network operation now that we all use, and there doesn't therefore seem to be a practical problem in preventing the infrastructure from taking effect.
But your interpretation, you may start off with the most wonderful site, but the effect is, as soon as you've become the occupier, you've snuffed out any possibility of anybody being able to confer further code rights on you for that site.
Yes, subject to two things. First, for that very reason, you will have got a long-term right, or the long-term option, an option for a long-term right. And secondly, your rights of renewal against the person with whom you've made an agreement are granted clearly by Part 5 and do not involve the test of occupation, who's in occupation. The Part 5 renewal rights are to parties to the agreement, not to occupiers, or not as between occupiers and operators. So once you've got your agreement in place, and I'll need to show your lordships and your ladyship how this works, but once you've been conferred certain rights, you can have them renewed at termination under Part 5. And at that stage, occupation has nothing to do with whether or not you get a renewal. So you can commit at the beginning, you can say, I know this chap's got a 20-year interest, that's good enough for me. I will take a 5-year term, that's good enough for me. And at the end of it, if I want it some more, I will take another 5 years under my Part 5. Looks like I'll be able to do that. That's the kind of money I want to make from this site. And that's the kind of thinking.
Wouldn't you be better off as an operator saying, I'll just go initially under paragraph 9 just for a 6-month thing, because I know that once that fixed term expires, it will roll forward under Part 5, and then it doesn't matter who the occupier is. So it doesn't matter how precarious the occupier's rights are at the time that the rights are conferred, because they become much more solid. How does that work when they roll forward?
You can take certainly you can take a 6-month term if that's what you want. But if the operator's gone by then, the party to the agreement is sort of irrelevant to the process.
Sorry, when you said if the operator has gone by, did you mean?
Sorry, I mean the occupier has gone. Yes.
And can you just say that again? So if the occupier has gone,
if you have a short-term agreement and you want to renew, then under Part 5, you can only renew against the parties to the agreement. And if
the original agreement.
The original agreement. Well, the original. I'll come to the refinement, but yes, the original agreement. What you won't have done is but have bound the landlord to any length of term after the 6 months, because he's not obliged to agree anything. And so the situation will arise that the landlord will say, well, I'm not bound by any of this. That occupier's gone. Doesn't matter what he agreed. I'm now going to exercise my rights to take back occupation. And then that is where you get into all the provisions that my friend took the court through yesterday of Part 6 and removal of apparatus and so on. And that all has to be worked through as well.
Well, I don't know.
But just to try and simplify the position, the fact that you have to deal with the occupier to grant appropriate code rights means you're stuck with whatever limits exist on that occupier's rights to grant you code rights. And nobody is obliged to be bound by any further length of time, as it were, in reversion after that occupier has gone.
And nor can the court so require.
Correct. Now, as I say, that may be, or it's important to register that policy choice creates some uncertainty. The consequence of that is, and which the operator must respond to, is that he finds an occupier with a sufficient length of interest that enables him to put up his mast for as long as he needs to. And I may say also, don't come away with the impression that this is an entirely static process. These sites may be long-term, but some of them are for so long as they are needed, and they're improved by being moved, or there's a lot of activity in setting these sites up. So once you've recovered your capital investment and made the profit that you set out to make from a particular situation, then the operator is at liberty to move on and try and make some more money from somewhere else. So it's not putting in place a fixed infrastructure which then remains binding on everybody who then follows. You're stuck with whatever you can get from the rights of the occupier that you're forced to deal with.
Yes, but the number of years over which you have to write down the investment is going to feed into the regulatory controls on what you can charge.
Yeah, it's all very complicated. I'm not suggesting it's straightforward in that sense.
So it's rather contrary to the interests of the consumer if all these costs have to be written down over a short period of time, and the regulator has to set a price limit that enables them to be depreciated over that short period of time.
Yes, that's true as far as it goes, but remember the purpose of the code was not just to put in a network come what may, overriding all other interests. The idea was to strike a fair balance between landowning interests and mobile operators. And that's really an important consideration.
Why is this in the interests of the landowners for this to work in this way?
Well, because it's an interference with property rights. The public rights, the code rights that are put forward are an interference with property rights. It's a form of compulsory acquisition, in effect. And so the idea is that you as a landlord will have to give up your rights in certain situations in exchange for compensation and consideration if you're the occupier. But that's the limit of it. You don't insist, or the code does not insist that the mobile network trumps all other considerations. On the contrary, it says we're going to roll this out by incremental agreements between occupiers and operators, and over a period we will have an up-to-date network. It doesn't all have to be tomorrow. The DCMS report at the end talks of the new code taking effect across a period of something like 10 years. So these adjustments, this new code arrangement, will take place, one can assume, over a kind of 10-year period, maybe longer. And it will be done incrementally by this agreement by agreement with individual operators according to individual sites. And that's the nature of the code rights that we're looking at?
I'm being slow here, but I still am struggling, I'm afraid, just to understand how it works. Paragraph 9 is the paragraph for creation of a code right.
Yes.
And that says, may only be conferred on an operator by agreement between the occupier of the land and the operator. So it seems to focus on an agreement between operator and occupier for the time being. Now, an agreement between two private parties can be as to anything. So, I mean, I was putting to you occupier who has a precarious title, don't know how long it'll last. But even if it's known that it's going to come to an end, let's say in 2 years, you can still, as a matter of private law, promise 10 years, 15 years. What I'm struggling to understand is paragraph 10, as Lord Hodge was pointing out, 10.4, seems to operate on the predicate of, well, what rights, code rights, have been agreed between operator and current occupier. And let's say very precarious occupier, but they promised 15 years of rights. Paragraph 10.4 seems to say, well, you can go to the landlord or anyone else you can find that might have superior title, who might be in a position to kick off the current occupier, and you can ask them to be bound by it. And in sense, of course you can. You know, they can agree if they choose to. But then paragraph 20 sets out a mechanism to seek to compel not just the current occupier, but also the persons to whom 10.4 would apply if they're agreeing themselves. Now, it's true that one has the preconditions in paragraph 21. So the court would only impose such an agreement on the person with title, let's say, in the example I'm talking about, if the court is satisfied that they're getting sufficient remuneration, if you like, consideration under the terms of the agreement that's to be imposed for what they are sacrificing. And it may be that if the occupier has a very precarious title, and that hence the landowner's title is genuinely correspondingly great, that the court would then say, well, the consideration which is required to be imposed on the landlord will be correspondingly high. But if it's satisfied that the conditions in paragraph 21 are made out and there is a sufficient consideration being given to the true landlord, then it seems to have the power to impose that agreement on the true landlord. And it might be said that that would be a good way of the system working, in the sense that you know who you go to set the whole system, the whole ball rolling, the occupier who confers rights under paragraph 9, and then you protect yourself against the fact that that occupier might be gone tomorrow by going, in effect, to the landowner, and if they won't accept the terms you're offering them, you ask the court to impose that agreement upon them. What's slightly confusing me is the suggestion that you seem to be making that the occupier can only make a promise as to code rights which is coextensive with whatever interest the occupier seems to have. Whereas I thought, because the code right depends just upon an agreement that the occupier and the operator make, and you can agree anything, that wasn't the proper approach to the way the code works.
Yes. The problem with that way of looking at it, if I could...
Yeah, please. I'm not
is that take the most obvious example, is what happens to the consideration that's payable to the occupier under the agreement when he ceases to be in occupation. So on your Lordship's example, you have a 10-year deal, the occupier goes out next week, but there's an obligation under the 10-year deal to pay the occupier
Well, wouldn't you put a term in that if it's precarious, that if you go out, then I won't be paying it to you, I'll be paying it to the landlord, and it'll, in your agreement with the landlord, it'll say the converse thing.
Yeah, I mean, in effect, as against the occupier, there'd be a failure of consideration for what you're going to pay them, and if you were, and the landlord, when you approach them under 10.4, would want to cover that situation and say, well, if I'm going to be stuck with the mast, and the occupier goes, you have to pay me, and the court, looking at applying paragraph 21 to see whether the landlord's interest as the relevant person is sufficiently protected, would likewise be looking to ensure that in that situation the rent goes straight to the landlord, isn't it?
Well, I've briefly, I think, explained the flaw. The reason is that getting an agreement between the occupier and the operator binding on the landlord doesn't involve any change to the terms if the occupier goes out of occupation. So that otherwise you would have a three-way deal, essentially, between an occupier, a landlord, and an operator, under which the occupier essentially confers rights for the first period while he's there. And it's the landlord who then, as it were, takes up the reins after the occupier has gone out and receives the benefit and is bound by the obligations, which is to give the rights, to continue to observe the rights. Now that is the conferment for a short period by the operator and a longer period by the landlord. Yeah. And that is why it falls foul of paragraph 9. The conferral by the occupier can only be in relation to what he's got that enables him to confer rights.
That's what I'm struggling with. Why do you say that?
Because the landlord at this stage is not in occupation and does not need to be dealt with at all, and so is not the person who is going to grant any rights in the future or observe any rights in the future after the period of the occupier's occupancy has come to an end. But so at the outset, the proper analysis of that is that the substantive conferment, as it were, is being made by the occupier for the period of his occupation and thereafter for the landlord. And that's not what paragraph 9 allows. Paragraph 9 says you can only have conferral of rights by the occupier, and that is limited to his period of occupation.
But because a period of occupation is a factual matter, but the promise is a normative matter, even if the occupier thinks he may be in occupation for 10 years and hence makes the promise for 10 years, there may be all sorts of reasons why he goes out of occupation within that 10-year period. As my lady said, he may fail to pay the rent and forfeits his lease or something like that. Yet, I mean, looking at paragraph 9, and this, I may just be deeply confused, but paragraph 9 seemed to me to operate on the basis of whatever is the private agreement between the occupier and the operator. And as I say, they can agree anything. It might be sensible that the occupier seeks to agree a period which he genuinely thinks he will be in occupation for, even though he can't guarantee that. But it doesn't say that he's limited to doing that. So even if he thinks, well, the likelihood is I'll be in occupation for 2 years, but I'm going to offer 15, on the hope that I might be able to myself negotiate with the landlord some more. So he makes a private contract conferring code rights on the operator for 15 years. But then the operator, if they want to be protected, because indeed the occupier may be kicked out after 2 years, does have to go and make sure that those rights, which ostensibly he has under a private agreement, are going to be made to stick against a third person, in our example, the landlord. And paragraph 10.4 seems to give the mechanism whereby you can do that. And paragraph 21 and paragraph 20 enables you to go to the court if the landlord won't agree. And paragraph 21 says, and the court will properly protect whatever is the interest of the landlord who's going to be bound by those code rights. The effect of which would appear to be occupier has promised code rights of 15 years, but may not be in occupation throughout that 15 years. But if you've followed the course through 10.4 and 20, you will have an agreement also with the landowner. And you're quite right, it will be a tripartite arrangement, if you like, but the operator will need it to be a tripartite arrangement because the operator wants the landowner also to be bound precisely because the landowner may come back in.
I do get your Lordship's point. I absolutely understand.
Again, I'm not trying to persuade you of it, but I am genuinely mystified at the moment as to how this works.
My answer to it, and apologies if I'm repeating myself, but my answer to it is that there's one agreement that takes place, which is between the occupier and the operator.
Right.
There's no agreement or no agreement conferring anything, conferring rights of any description, to which the landlord is a party. The landlord takes the agreement between the operator and the occupier at face value. It's bound or it's not bound. And it doesn't change it. Now, following that thought through, the operator is not going to commit itself to 15 years' worth of payment with an occupier if he's only going to get from the occupier 6 months of use of the site.
Okay, I mean, I can see that as a practical matter. I was asking for help on the conceptual side.
Well, the practical is the conceptual here, because what happens then when the occupier leaves? The answer is, under the agreement with the occupier, the operator still has to pay the occupier.
That depends what the terms are.
It depends what the terms are, yes.
You would expect to say that I won't have to pay you if you cease to be the occupier.
I mean, at a conceptual level, your analysis really is more like a property law analysis. The occupier cannot give that which he has not got, nemo dat quod non habet, while Lord Sales is putting to you a contractual analysis, namely that someone can make a promise to do something which
I can sell you London Bridge.
He turns out unable to do. And the circumstance we're facing here is that the Part 2 or the code rights are a sui generis statutory regime, and we have to construe this statutory regime to see whether it envisaged a property law analysis or a contractual analysis.
But even on the contractual analysis, my submission is that this is all hypothetical, in the sense that the reality is you do not bind yourself to the occupier for 15 years, and that means actually paying him, every month for 15 years, if you're only going to get back from him.
I follow that. You don't pay for something you're not going to get, but Lord Leggett says, and so you write it into the contract, you make it clear in some way that you're not going to do that.
But the landlord says, and this is just taking it to the next stage, the landlord says, well, I'm not going to agree to 15 years unless I get paid for the rest of the period. Now, let's assume that is the situation. That means that the operator is going to be, even conceptually, this means the operator is going to have to pay twice over. He needs two contracts.
Well, if he didn't like that offer, he could go to the tribunal and get them to impose what they thought was a fair solution. I could see it's more trouble than it's worth in real life, perhaps, but which is why you look for somewhere else. But there's no reason why you can't do any of this in the code, is there?
And also, just as a practical matter, wouldn't you as an operator, in effect, in the negotiation under paragraph 10.4, say to the occupier, I'll pay you while you're in occupation, but of course I won't when you're not in occupation, so you limit that. And you say to the landlord almost the converse, I won't pay you, or I'll pay you only a modicum while this chap's in occupation is the person actually enabling me to provide my service. But if he goes out of occupation and you're the person who stepped into the occupier's shoes, if you like, then I'll pay you.
But then that is in respect of the code rights.
Yes?
That's the problem. You run into paragraph 9 problems, because effectively that means that after occupation has come to an end, the landlord is the one both collecting and conferring the rights and obligations on the balance of the agreement.
No, no, because the conferral takes place, and if the conferral is a 10-year right, it takes place at a moment in time, and the right then exists. There is not a day-by-day conferral of a right here.
Yeah.
Well, there can't be, because it can't be a day-by-day conferral, because then if you combine that point with the point that as soon as he installs his ECA, he becomes the occupier, you can say it's 15 years, 2 years, whatever. It's going to last 3 weeks, because as soon as the operator goes into occupation, the occupation of the tenant ceases.
And I'm sorry to pile that on you, but just looking at paragraph 9, a code right is conferred by an agreement between the occupier of the land and the operator. An agreement is something that occurs at a particular point in time, which I think is what Lord Hodge was putting to you. Yeah. So you can have the agreement with an occupier who everyone thinks is going to be there for 1 day, but he's there now.
Yeah. Well, it may be that it's a difference between theoretical and practical, but practically, at least, an operator is not going to enter into a deal of this kind with some kind of precarious occupier.
I can see the force of that. I mean, there's a lot of work involved in setting up the system which we've been presenting to you on a hypothetical basis.
Well, maybe that's as far as I can take the position now, anyway. What I do point to, though, under paragraph 9, whatever the precise consequences of paragraph 9, is that there is no alternative procedure set out in the code for what should happen if there's some kind of difficulty with identifying the occupier or with the limitation of his rights or anything of that kind, so that, or the particular point that's taken against me, where the operator himself is in occupation. There's no alternative to the simple position set out by paragraph 9, which is that you do the deal with the occupier. So where my friend and I part serious company is that although we both regard paragraph 9 as fundamental, he would say that notwithstanding that, there is a fallback position in particular circumstances where the operator is himself the occupier. And that's really the issue that it's the heart of these, at least a central issue at the heart of these appeals. And there is nothing. The first point to note is there's nothing express on the code that says anything about some alternative mechanism by which rights can be conferred. It would also need, one just thinking about it, would need to be quite a detailed and complex provision, because you'd be looking to identify a number of different possibilities that might exist if you can't identify the occupier, or if he's the wrong kind of occupier for your purposes.
But it wouldn't, because all you need to exclude is the possibility that there's nobody else you can identify easily, because the person identified by the test is you. So all you need is some sort of provision, and you can make the point quite fairly that it's not there to be found, but that the occupier can't be the operator, but it's whoever else is identified by applying the statutory test.
But with what consequence? If it's not the occupier, then who? Are we talking about the next one up the chain, another occupier, the head landlord? I mean, these things have to be thought through.
But it doesn't matter if you can just apply to have them bound by 10.4. as many
Can I just...
Sorry, and just to follow on, if I may, isn't that the point of the cascade?
Yeah.
Well,
That's
that's a different point, because...
Well, it's related. Let me just put it to you, and then...
Of course.
It seems to me to be related, because if one did say that occupier in paragraph 9 definitionally cannot be an operator, if one makes that move, then when you come to seek to, you're an operator and you're seeking code rights, you're dealing with land which relevantly is unoccupied. I'm looking at paragraph 105.
You're driven into 105.6.
And then you're driven into 105.6. So just, I can see difficulties with the definitional move. I follow that. But if one makes that move, what's so difficult about operating the cascade in 105.6?
Well, one has to get to an assumption that without the ECA tuning out whatever is the presence of the operator, there is nobody who therefore would count as an occupier of what remains, as it were. If you think of, all my friend has said is you get rid of the lease, you conceptually get rid of the apparatus on site. And he says you also forget about the fact that there have been managers and surveyors and people on site from time to time. Just forget about everything to do with the operator. It doesn't follow that there's no occupation by that site in that hypothetical world. In that hypothetical world, all you're doing, all my friend is saying you're doing, is you're getting rid of the operator.
Yeah, well, that's what he wants to do, so he can find somebody to contract with.
But you're not doing anything about examining what the position would be without those people on site and without those matters on site. The assumption is made.
Does it really have to be that? I think what you're saying is, well, if you tune out things like the ECA, you don't take those into account, and that's the reason why you say the operator is not an occupier. Then in this sort of make-believe world, one has to cast around, first of all, to see, well, is there someone else who would be the occupier, which might be complicated, and only then do you go into the cascade. But what I wanted to ask is, does it have to be that complicated? It may be as plain as a pikestaff that it's the operator who is in occupation on the facts on the ground. The definitional move, as I keep calling it, doesn't involve creating any hypothetical world. You just say, in this situation where the true occupier is an operator, we will treat that as unoccupied land. So you don't create a make-believe world or try and think of what the position would be, assuming the ECA wasn't there. You look at the true position, you know from the true position that the operator is the occupier, and you then say, but if that's the case, for various other reasons the code can't be made to work, therefore we will treat this as unoccupied land, and then you're just straight into a cascade.
So if the original occupier occupied a large piece of land and a small piece of land was taken out of his occupation by the operator, is the idea that the land formerly occupied by the ECA would then revert to the occupier, or is the occupier's rights exhausted now because of the code rights having been granted and the ECA being put up, and you go up on a title to the title, which I think is the last stage of the...
I thought you just, in your sort of simple case, because you say in practice you only deal with somebody who's got a clear title, once the operator drops out of the picture, you're back with the person you began with. He's the only other person in town.
Well, what I have ringing in my ears is the Law Commission observation, which is to be found at 2174 at 330, paragraph 330, which is that, commenting on the paragraph 9 arrangement, It says any other arrangement would be impractical. So far as the framers of this legislation is concerned, they did not want to make an exception for any particular circumstances because that would create impracticality.
Well, I'm not sure they're addressing here the situation where it's the operator who's the occupier, are they?
No, they're not. But except that they're not addressing that specific point, of course. But that just goes back to my general point, which is that this code does not take into account that situation at all, does not provide for it at all, and in fact provides for something quite different. It doesn't contain this exception that my friend is seeking to have imposed. And there's no material in the code itself from which you can spell out, that is, from which one can spell out that kind of exception. So, I mean, in the end, that's the most important point in all of this. My friend says there's a problem, which we disagree that it's a problem. We say it's inherent in the policy decision to make rights arise from agreements between occupiers and operators and not otherwise. So we say it's not a problem. That's just the consequence of what's been carried out. But if he says there is a problem and it needs to be rectified, there is nothing in the code which gives you the basis upon which you can come up with a suitable alternative process. It's at the best, it's going to be a guess.
Yes, I mean, your point is this is an exercise of statutory interpretation.
Yes.
And that you say there's nothing in the code expressly or by necessary implication that gives rise to the solution, one of the solutions
yes.
put forward. And you say in any event there is no one obvious solution that can be read into the statute.
Yes.
I think that's really what it comes to.
In a nutshell, I'm grateful, Your Lordship.
But is it correct that the government are proposing a solution which is to ignore the operator for the purpose of identifying the occupier?
It's proposed a solution. The underlying consultation paper was that that's because the code needed to be amended.
Yes, but I mean, it shows there's nothing, unless you say it's an unworkable solution, it comes really down to a question of whether one can get there by interpretation or whether it needs the legislature to put something into the code to achieve that effect.
Yes, I wasn't going to make submissions on the proposed amendment. If Your Lordship, Your Ladyship are interested, we don't think it actually meets the case properly. But right. It will be what it will be, and it's too early to start trying to constrain it because it's just a proposal at the moment. Mm-hmm. But something, one can say that Parliament has recognised there may be a problem that needs to be resolved in the interests of operators. It has been persuaded that that's the case, in which case something may emerge from the parliamentary process. So the question then for Your Lordships and Your Ladyship is, do we need Parliament to intervene, or is there material upon which we can act? And my answer to that would be emphatically not. There is nothing here that enables you to do other than give effect to the plain terms of the code.
Yeah.
And there's two elements. A, the code's plain, there's no necessary implication. Even if there was a purpose of construction, you say there are several options, and it's not for the court to devise a legislative scheme. Precisely.
Now, let me go back to the code itself. I've probably done enough with paragraph 9. Paragraph 10, I'm looking at page 18 and 15, is then the provision about who else is bound by code rights. And 10.1 sets out that this paragraph applies if a code right is conferred on an operator in respect of land by a person O, who is the occupier when the code right is conferred, If O has an interest in the land when the code right is conferred, the code right also binds the successors entitled to that interest, and then B and C are effectively derivative rights or interests from O's interest. And then 3, a successor in title who is bound by a code right by virtue of subparagraph 2A is to be treated as a party to the agreement by which O conferred the right. Now, I do draw that to the court's attention because it will have an effect, as we'll see, when we get to Part 5, and it appears to be its effect under Part 5 that is the reason for this paragraph in this subparagraph in this paragraph. Going on, the code right also binds any other person with an interest in the land who has agreed to be bound by it. And then there's an equivalent position for his successors in title and persons deriving rights from his interest. And then, again at 6, a successor in title who is bound by a code right by virtue of subparagraph 5A is to be treated as a party to the agreement. So not derivative rights, but successor rights mean that the successor is to be treated as a party to the agreement. Now that, as we'll see when we get there, is important when it comes to rights of renewal. For the moment, I just ask your lordships and your ladyship to register that that is the position. As for who are the persons to be bound, well, it's not stated. It could be anyone with an interest capable of being affected, but I think in answer to your question from my lady, Lady Rose, I suggested the most obvious ones, which are people whose consent is needed for the valid exercise of some kind of occupier's power to share occupation in whatever form that may take, and to avoid breach of covenant or other agreement. The next clause is clause 11, which is about the formalities, and I'll come back to that, but essentially for present purposes it says that you have to put it in writing, and there is a provision, express provision, that it does have to have a clause saying how long the right can be exercised. 12 is then the provision my friend Mr. McGee took you to, saying that the exercise is as a statutory power with certain qualifications, but for my purposes that doesn't take the position further. Then briefly looking through Part 3, we have 16, which sets out some minimum rights of assignment, and 17, which are the minimum rights of upgrading and sharing. And those are, I think we're all agreed, those are rights that cannot be contracted out of, and so they will apply to any new code agreement, that is, any code agreement under the new code. So then we get to the important provisions of Part 4, which is the power to impose an agreement. And 19 sets out the circumstances in which the court can impose an agreement. It says that this part of this code makes provision about the circumstances or certain circumstances in which the court can impose an agreement on a person by which the person confers or is otherwise bound by a code right. And then there's the test, the effect of the agreement, and the imposition of agreement on a person on an interim or temporary basis. And paragraph 20 is, as it were, the paragraph that tracks what we've just read under paragraph 9 and paragraph 10. So this paragraph applies where the operator requires a person, a relevant person, to agree either to confer a code right on the operator or to be otherwise bound by a code right, which is exercisable by the operator. So it's exactly the language that one's deduced from 9 and 10 being replicated here. And the procedure means that the operator may give the relevant person a notice in writing setting out the code right and all of the other terms of the agreement that the operator seeks, and stating that the operator seeks the person's agreement to those terms. Now, my submission is that that is clearly to be read, as it were, disjunctively or respectively. So, in the case of a notice in writing, you would not put a notice in writing requiring anybody to agree the terms of the agreement that the operator seeks, other than the occupier, who is the only person who is able to confer rights upon you under paragraph 9. Ditto, you would not serve a notice on anybody stating that the operator seeks the person's agreement to those terms unless that person is somebody that you want to have bound under paragraph 10. My friend Mr. Sietler's submissions seem to elide these two distinct notices and two distinct persons who are wrapped up in the definition of relevant person. But it is, in my submission, tolerably clear, if not conspicuously so, that what is being suggested is that these notices are respectively served on the person who would have been able to do it voluntarily if they had so chosen. And then there's a period elapses, but it's a 28-day period, and then you can make an application.
It's hard to think of any sensible reason providing that the court can impose an agreement without providing the opportunity for people to agree it for themselves without going to the court.
Quite. So, and to give relevant notice of the application that's coming if you don't agree. So all of that, I would suggest, is perfectly straightforward and simple. And Mr. Sietler's submissions are just complicating a perfectly simple position. Paragraph 21 then sets out the test, in particular the public interest. We've seen all that.
It does suggest that there is supposed to be a public benefit override for the reluctant occupier or person to be bound. Whereas if you're right, then if I'm the occupier with a long-term interest, I don't want, for whatever reason, to grant code rights. I get one of these notices, I look at the conditions and say, well, those are clearly going to be satisfied in my case, but I will grant a 2-year tenancy to subsidiary company, and that then will stymie this, because then that subsidiary will be in occupation but only for 2 years, and no, the court cannot grant a longer period of code right.
Yes, I mean the trouble is one can think of examples the other way, which is that you apply to an occupier whom you know is going to be out next week and get a 15-year deal with him, and then say, oh, I'll have that binding on the landlord, please. It's not, I mean, these sort of hypothetical things, in a sense, don't take the argument too much further. They're all hypotheticals, but one has to work out what the position ought to be. My position is that the provision in paragraph 9 means that you deal with the occupier so far as he can grant you rights. And that agreement then is either binding on somebody or it's not. There's no refinement to it or no change to the agreement if the occupier's interest falls in. It's just a yes or no to the deal with the occupier. And that reading then really rules out a lot of the sort of hypothetical possibilities that one can think of either way, and gives effect, I would suggest, to the objectives of the code. The ultimate endpoint of all of that is that if you're an operator, you're well advised to go to somebody who's got a secure enough right for you to rely upon. And that's all good. That's all good for the network. That's what we want, is something that is secure. Paragraph 22 has assumed some importance in Mr. Seitler's submissions at least, which is that an agreement opposed by an order under paragraph 20 takes effect for all purposes of this code as an agreement under part 2 of this code between the operator and the relevant person. I think the suggestion is that this could validate an agreement ordered by the court, even though the rights are conferred by a non-occupier. Now, if I'm right on the meaning of paragraph 20, only an occupier can be the subject of an order conferring an agreement. Sorry, ordering him to confer an agreement as sought by the operator. And only a party intended to be bound by that agreement would be the subject of an order that he be so bound. And so paragraph 22 doesn't apply, or in practice can't apply, to rectify any difficulty that's emerged as to the parties. The parties have to be the right parties, and then the right order is made against whichever party it is. And once it's made, the agreement takes effect for all purposes as if it were a voluntary agreement. Now that's all readily comprehensible, but it doesn't mean that you can ask a non-occupier to grant rights that a non-occupier can't grant under paragraph 9, which I think is where Mr. Seitler goes with this point. So paragraph 22, we say, has a more limited effect than he would suggest. We don't disagree with Mr. McGee that some consequences are readily apparent, like, for example, 16 and 17 assignment and upgrading and sharing rights. Those will all apply to an agreement that's ordered by the court under 20. There are others as well. Mr. McGee drew the line, I think, at rather early in the code. The most important one, or one of the most important rights that follows from such an agreement, is Part 5. You have all the rights under Part 5 to renew your agreement at termination. So it does have that kind of effect, which is all, we suggest, readily apparent from the terms of the code. We then have various terms about what should, how the court should proceed on an application under paragraph 20, and they're all set out in 23. There's another provision like the ones we've seen in paragraph 11 at 23.7 about the terms of the agreement must include terms specifying for how long the code right confirmed by the agreement is exercisable. Now, all of that, we say, is because when you get to termination, you need to know whether the original agreement has ended or not, and then certain consequences follow from it. I needn't go to anything in 24 or 25, save to note that the no network assumption in 24 has dramatically altered the consideration picture for those of in my client's position. So there's a lot of there's a lot less money payable under agreements of this kind than one would have expected 10 years ago. So
that's why I was slightly surprised when you said that the aim of the legislation was to create a fair distribution between the operator and the landowner or your organisation. I mean, the new code is geared very much in favour of the operator.
It is slanted in favour of the operator, yes. but without forgetting the rights of the landlord. And perhaps the easiest way to illustrate that is that the new right of renewal under Part 5 is a right that is shaped from the 1954 Act and was intended to create that kind of fair balance. So you don't get a renewal under any circumstances, but you get it according to proper notice procedures, a proper consideration by the court, taking into consideration all the circumstances and so on. And so you end up with
you get those things, but in terms of the cash,
yes, the cash.
the greenfield site,
Yeah.
You end up with a lease of agricultural land, in
Yeah.
effect.
In effect.
Yes.
Yeah. So that's consideration 24, compensation 25. 26 and 7 are the ones that my friends both rely on specifically, and I'll have to deal with those in rather more detail. But I'm anxious to hurry on and get to part 5 at this stage, which is the termination and modification of agreements.
Just before you start on that, if I may, can I just, because it is linked, just take you back to paragraph 11, the variation provision. I'm assuming that if we've got an occupier and an operator making a code right agreement, and the operator has now got ECA on site, there is no problem about those parties varying the original agreement. Is that correct?
It would seem not. I tentatively suggest it would seem not, just because the Court of Appeal also tentatively suggested. I think they were satisfied, but they were rather more tentative about it than saying, yes, that's obvious. The
That was the Court of Appeal
in Compton Beauchamp. I'll find the reference in due course.
Thank you very much.
If I can. The reason why that's not an obvious answer is that although paragraph 11 seems to contemplate variations, voluntary variations that is, part 5 is covers all the variations you could possibly want. What it says is, looking at 28, this part of the code makes provisions about the continuation of code rights after the time at which they cease to be exercisable, procedure for bringing an agreement to an end. C, and this is the important one for your Lordship's purposes, the procedure for changing an agreement relating to code rights. Now, one possible construction of that means that you can't change it otherwise. So once you've got a code agreement in place, for it to continue as a code agreement subject to variation, changing as the word is here, you have to wait to the end of the agreement, which is what part 5 delivers, and seek the variation through the procedure that is set out in part 5.
But why did you say earlier on in one of your submissions that, in a sense, you've got to get all your ducks lined up from the start? I think you said. You've got to work all this out right from the first agreement. If it's the case that paragraph 11 allows the operator and occupier, including, for these purposes, the operator who has now gone on to site with ECA, if that's the case, you don't actually need to get your ducks all lined up, do you? Because you can voluntarily arrive at a variation.
Well, you can't arrive at a variation which includes the grant of an additional code right if the effect of what you've done so far under the agreement is that the operator has gone into occupation. So looking generally, leave that point to one side, the occupier going into, sorry, the operator going into occupation. Leave that point to one side. The suggestion would then be, well, I suppose they're subject to an agreement. They can agree variations whenever they want, no problem. The problem that's injected into it is because if you want to confer a new right on somebody, a new code right on somebody, then you need to make that against the occupier. And on the sort of facts that my friends are concerned with in these cases, the operator may be the occupier and not the occupier.
So I think the answer to my question is that paragraph 11 has got a problem in it.
Yeah. It's a problem. The Court of Appeal was satisfied that you could make adjustments, and they were not satisfied about code rights being added on.
Right, but your submission is that you think you can make variations provided it's not the conferral of a code right.
Yes. I mean, I've complained.
What is the code right? Suppose in the agreement, what you agree is, I'm happy with the tenant to have you put wires on poles across my land, but I don't want you digging trenches and installing things like that, or the other way around. I'm happy for you to have your pipes entrenched in the ground so it doesn't spoil the view, but I don't want a whole lot of poles and things. Now, is the code right the right expressed in 3, whatever it is, to install on or over or under land? Or is it, in that circumstance, only a right to install under land, so that if I later relent and say, well, all right, you can put up a pole, that's a different code right, because the right is not the right actually described in 3D or whatever it is. It's the right in 3D as expressed in the actual agreement.
My answer to that would be that because the code right, as listed in paragraph 3, is expressed perfectly generally, the code right is the basic right. So you have the right to lay a cable, say. The terms upon which you're entitled to exercise that right, like no work on Tuesdays and Wednesdays and limited access and putting things back, those are terms that relate to the right rather than the addition of a new right. So that theoretically, one might say that the parties could agree variations as to the terms upon which a right should be exercised, rather than a new right. The problem with that kind of approach, however, is that when you get to Part 5, the modification that is permitted and allowed by Part 5 includes modification of terms of the agreement. So let me just take your lordships and your ladyship to paragraph 33. This is under the general heading, how may a party to a code agreement require a change to the terms of an agreement which has expired? And then there's a provision about you can require the other party to the agreement to agree that. And then there are 4 things that you can ask them to agree. One is that the code agreement should have effect with modified terms. And then the others are you lose a code right, and then you confer an additional code right, and then you terminate the whole agreement and have a new agreement altogether. Now, if you've agreed modified terms as part of the process, it may be said, consistent with my argument as regards additional code rights, that that's not something that you can therefore agree, because you can only agree modified terms in accordance with the Part 5 procedure after the end of the code agreement. So in answer to your latest question, there's a problem there, and it's not quite clear what it is, what the answer is. There is a tension between paragraph 11 and Part 5, paragraph 33, in that respect. I think my conclusion, my submission from it would be that paragraph 11, and indeed the position of an agreement, a voluntary agreement generally, is that you would expect voluntary changes to be made. So that is perfectly possible. And that Part 5, the reference to modified terms, means you can do it then as well.
Or you can require the court to do it.
Or you can require the court to do it.
I mean, it only applies in 33 after the agreement's expired.
That's right.
And that's when you can't agree it yourself because the agreement's come to an end.
That's
But
right.
it doesn't mean that before the agreement's expired you shouldn't be able to agree something
Correct.
if you want, does it?
That doesn't. But the additional code right may be a problem if you've lost if the occupational rights have changed in the meantime, because then you're stuck by Section 9 that you can't agree something. But let's just think about that. If you have agreed a variation, a voluntary variation under paragraph 11, you don't go to court. That's not what the position is. A variation is not allowed by paragraph 20, just the conferral of rights. So it's consensual only. When you get to the Part 5 stage, you can ask the court to, as it were, validate or pick up the points that you've agreed consensually, and then the whole agreement will work in its revised form from then on.
But isn't it not an alternative interpretation that if we've got an issue about the scope of paragraph 11, which I think is what you're saying is actually slightly problematic, one might say the natural reading of it is we're talking about the original parties. It's got to be signed by or on behalf of the parties to it. That is therefore clearly the occupier of the land and the operator, as they were at the time when the original agreement was made, and that is therefore how the variation works. Those same parties can make the variation.
Yes, subject to the refinement, which we noted earlier, which is that the party to the agreement is either the original occupier or the successor in title to the original occupier. That's the effect of the provisions in paragraph 10 that we looked at. You remember there are two clauses there which say the successor in title will be treated as a party to the agreement. And that is why those paragraphs were allowed, and that is to make sure that the successor can access the rights of modification and termination and so on under Part 5. So there is another person who is capable of making those kinds of variations that your lordship's positing.
But the successor to the original occupier, if the original occupier long ceased to be the occupier because now the operator is the occupier, the successor is also not the occupier because the operator is the occupier.
Well, if there's an occupation problem, that's absolutely right. But occupation is not relevant to Part 5.
No, but it's relevant to paragraph 11.
Yes. So if there is an occupation problem that prevents the grant of an additional code right, then that problem will affect the successor in title as well as it affects the original occupier. So going back to the beginning of Part 5, we've looked at what the procedure is intended to do, and 29 sets out what is, this is 5, what is a code agreement. There's the definition of code agreement. And it's basically 29.1, which is an agreement under Part 2 of the code, which is why I say Mr. McGee left out from the consequences of paragraph 22 the sort of deeming provision that you can also have Part 5 renewal rights. So if it's a Part 2 agreement or something that works as a Part 2 agreement, then you can access this part of the code.
Yeah, I think in fairness, Mr. McGee did mention that point. It may not have been in his list, but certainly I've noted.
Very good. I didn't spot it.
Agreement about it. Doesn't really matter.
So what it does is to exclude certain types of agreement. It doesn't really matter what they are. There's certain small agreements small categories of agreement, I should say, which are excluded from the protection. usually where they've got protection elsewhere, and then the residuary code agreements are then the code agreements as defined under 29(5). And 30 then, rather like the 1954 Landlord and Tenant Act, 30 then continues the rights even after they have come to an end by a fluxion of time. So, reading from 31 on page 1833, subparagraph 2 applies if a code right is conferred by or is otherwise binding on a person, the site provider, as the result of a code agreement, and the right ceases to be exercised, or the site provider ceases to be bound by it, or the site provider may bring the code agreement to an end so far as it relates to that right. And where this paragraph applies, the code agreement continues so that the operator may continue to exercise that right and the site provider continues to be bound by the right. And it doesn't apply to rights granted under 26 and 7. Now, pausing there, a point arose this morning about the expression site provider, which is defined in this paragraph as where the code right is conferred by or is otherwise binding on a person. So that goes back to the 9 and 10 distinction. 9 is the occupier who can confer. 10 is the person on whom it's bound. My Lord Sales asked this morning, well, isn't that the same as the relevant person under 20? The answer is not quite, because at the stage of paragraph 20, the relevant person is somebody who is the subject of a notice or the subject of an application to the court. Paragraph 30 is dealing with the position where the order has been effective. An order has been made, and those persons are now site providers because they are bound. They've conferred the rights, or they've been bound by the rights that have been conferred. So there's a slight change in nomenclature there, but it doesn't amount to anything because it's the same people that we've identified from paragraph 20 before. The other point I wanted to address your Lordship and your Ladyship about on this is from 30 subparagraph 2. You may recall yesterday some head scratching in discussion with Mr. McGee about how you purely terminate the agreement under Part 5. Not terminate and renew, but just terminate. And there doesn't seem to be a provision that allows you just to terminate. My suggestion is that actually the position is capable of being analysed under this paragraph, subparagraph, by analogy with what happens under the 1954 Act, which is a very powerful analogy for the true analysis of these provisions. Now, under the 1954 Act, you get protection, security of tenure, essentially for so long as you are occupying the premises for the purposes of a business. And the cases are that if you simply stop occupying for the purpose of your business, your whole rights under that Act collapse immediately. So you've brought to an end all your rights simply by not occupying anymore. And my suggestion is you could read 30 subparagraph 2 in a similar way, which is that this subparagraph applies the code agreement. Where this paragraph applies, the code agreement continues so that the operator may continue to exercise that right. So if the operator does not want to continue to exercise that right and packs up his equipment and leaves, then the code agreement does not continue for any relevant purpose. And so my suggestion is that in the example that Mr. McGee was making submissions on yesterday, of an operator who simply wants to leave, the solution is that he can just leave and there's an automatic termination.
So he doesn't have to give any notice to the site provider that he's...
No, not by analogy with the 1954 Act provision. So if I'm right in applying the analogy would be the same, because there's no notice required under the 54 Act. You just give up your occupation and you've lost all your rights in consequence.
But, I mean, it might be a bit difficult to tell whether you have or you haven't. You know, going back to the example of you walk off, you've abandoned the equipment, don't care about it.
Indeed. I mean, there are cases under the 54 Act where a similar kind of thing arises. So, for example, there's a case where the premises burnt down and needed complete rebuilding, and the landlord said, look, you've stopped occupying the premises for the purpose of your business. That's the end of your rights. You must go. And then there was an argument about what is occupation in the context of a burnt-down building where you want to continue to assert your occupation. So, yes, those kinds of issues do arise, but the basic point that I would suggest that the code is getting at here is that you only have the code agreement continuing while the operator wants it to continue.
Is that a convenient place
Yes, it is.
to hold?
It is, my lord, yes.
We'll resume tomorrow morning. Thank you very much. Court will now adjourn.